So, what are Section 100 changes? If you've ever reviewed California's executive branch rulemaking activities from the myriad of agencies and departments that adopt regulations in the state, you may have come across a Section 100 filing. So, what are those? Basically, changes without regulatory effect are known as non regulatory changes or non substantive changes, but often referred to as Section 100 changes. So, what's a change without regulatory effect? Basically, it's a change or changes to an existing regulation that, quote, do not materially alter any requirement, right, responsibility, condition, prescription, or other regulatory element of any California Code of Regulations provision. And this is found in Title I of the California Code of Regulations, Section 100A. So, Section 100, hence the name Section 100 changes, provides a list of examples of changes that do not have regulatory effect. It is not an exclusive list of changes without regulatory effect. Also, any changes which meets the general definition of a change without regulatory effect may qualify uh, as a Section 100 change with approval by the Office of Administrative Law, the OAL. In 1 CCR Section 100, it's titled Publication of Changes Without Regulatory Effect. And Section 100 provides that an agency may add to, revise, or delete text that's published in the California Code of Regulations without having to comply with the rulemaking procedures of the APA, only if that change does not materially alter any requirement, right, responsibility, condition, prescription, or other regulatory element of any California Code of Regulations provision. Now, Section 100 specifies that changes without regulatory effect may include, but are not limited to, one, renumbering, reordering, or relocating a regulatory provision; two, deleting a regulatory provision for which all statutory or constitutional authority has been repealed; or three, deleting a regulatory provision held invalid in a judgment that has become final, that's entered into by a California court of competent jurisdiction, a U.S. District Court in California, the U.S. Court of Appeals for the Ninth Circuit, or of course, the U.S. Supreme Court. Four, revising structure, syntax, cross-reference, grammar, or punctuation. Five, changing an authority or reference citation for a regulation. And six, making a regulatory provision consistent with a changed California statute if specified conditions are actually met. When an agency submits to OAL any changes without regulatory effect, the agency is required to prepare a written statement explaining why the change does not materially alter any requirement, right, responsibility, condition, prescription, or other regulatory element, and submit a copy of the statement with other specified documents. And thereafter, the Office of Administrative Law, OAL, is required to determine whether that submitted change is a change without regulatory effect. And then OAL files it with the Secretary of State and has it published in the California Code of Regulations. So those are so-called Section 100 changes.